All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. Let all who have cause to plead draw near, give attention, you shall be heard. God save these United States, this great state of Florida, and this honorable court. Ladies and gentlemen, the Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. Our first case and our only case today is number 2023-0539, Lorenzo versus State of Florida. Counsel.
Thank you. Victoria, we get all the power. All I do is do 5 minutes for the bottle. My client represented himself throughout both the guilt defense and the penal defense. Were incoherent legal theories and the trial court considered mitigation evidence that my client objected to. Those are the two issues. Whether my client was competent to represent himself, and two, whether the court should have considered the mitigation evidence by standby counsel. The first issue, mainly we are arguing that counsel should have been appointed based on my client's inconsistent and incoherent legal theories based on civil law. Yes, he had a code of appropriate behavior, but the record does show he did not understand the position against him.
Counsel, if I may, I agree with you that definitely the record shows that your client had court-appropriate behavior. It also shows, of course, that your client was convicted in the federal case. And while the record doesn't contain any records of the federal competency determination, we do have his federal conviction as a matter of record, and thus we can only assume that he was competent in the federal proceedings. What do you have to say about that?
He was represented in that case, Your Honor, and the state court has an independent duty to ensure the legitimacy of proceedings, especially in a death penalty case where my client is facing the ultimate punishment. And he was not facing that in federal court. The other point I would make is that the trial court made it even more confusing to my client by enlarging the role of standby counsel. If you look at the record, standby counsel was allowed to help him get evidence to the jail, asked for mitigation and experts on his behalf. Standby counsel acted like co-counsel rather than standby. And I think that further confused the issue here as to whether my client was competent, because my client did rely on the arguments made by standby. If you read his motions, especially in the penalty phases, and we argued that was confusing to whether my client was actually competent to represent himself. Are there any other questions to that issue? Issue 2. Every defendant, whether represented or person, has the right to control what the mitigation evidence is argued before the court. Lorenzo did present his own mitigation memo, and he did argue against the court considering the standby counsel's memo being admitted and considered, and the trial court overruled the objection and considered anyway as evidence, and he refers to it in the order, the final order. He referred to the standby counsel memo that my client did not want to be considered.
Counsel, can I ask you about that? So, in this case, that memo had been given to the prosecution much earlier in the proceedings, right?
Yes, sir, but if you look at the record, when the trial court asked for that, the prosecutor reminded the trial court that my client did not want that considered, and both standby and the prosecutor reminded the trial court that my client argued strenuously against that being considered.
I guess, though, do clients, though, have a right to prevent the court from requiring the prosecution to turn over any mitigating information they may have? The prosecutor is only ordered to by law to do the PSI. He turned over the PSI. I don't believe beyond the PSI that they're required
because beyond that, when there is an objection by the defense to the evidence, the evidence was not given to the prosecution with my client's blessing. It was given to the prosecution as by standby counsel.
Okay.
But that doesn't mean that the prosecution should give it to the court when the defendant does not want the evidence to be considered.
But the mitigation packet prepared by standby counsel, he was prepared by standby counsel early on in the case when he was first appointed, and he was trying to negotiate with the prosecutor to see if he could get a life sentence. I mean, the facts of this case and the mitigators are extremely strong. You got HAC, you got CCP, and you got among others. So the first thing I recall from going to those seminars is you got to save the guy's life. So that's what the standby counsel was trying to do, just get a life sentence, get a plea, and get this case done.
Yes.
Because it was going to get ugly at trial.
Yes.
And that's where it started, way at the beginning, as a memo to the prosecutor, hopefully to convince him to offer a life sentence. Then, of course, it was later considered. But at the Spencer hearing, I mean, Lorenzo said a whole bunch of things where he says something to the effect of, okay, I didn't want it in there. Well, now that's in there is part of the package, so it can only help me. So in a sense, I mean, he objected to it, but in the end, he was kind of glad it was in there.
Yes. This is, again, I think you also need to take that into effect that when you look at issue 1. But to your question, I would say that by then he already has objection overruled. There wasn't much he could do at that point, Your Honor. So that's my argument, is that he did not have much other options but to go with it by that point. Are there any other questions? Thank you.
May it please the Court, Assistant Attorney General Stephen Ake on behalf of the State of Florida. The State submits that the trial court properly allowed the appellant to proceed pro se in this case. The record clearly establishes that he had a rational and factual understanding of these proceedings.
How do you square that with his repeated assertions that he thought this was a commercial case?
He began this case at his arraignment with the sovereign citizen legal theories, and he also made he kept that up for probably a year and a half, the sovereign citizen arguments, but even when he was making those, at his arraignment and at the very second hearing when the court appointed the competency counsel, the defendant said, the trial judge was saying, this is a criminal matter. And he's like, of course I understand that, I just don't accept it. And I think that's his position in this. I think he was, at one of the hearings towards the end when he started kind of coming off the sovereign citizen thing, he made the comment that he was just bored in jail and had too much time on his hands. So I think that's why he was pursuing this. But it's clear, even in that first year and a half when he's making all these sovereign citizen claims, that he's also making discovery requests. He was aware of speedy trial. He waives speedy trial. He gets mitigation experts appointed. He's doing everything to progress this case along, because at that time it was set for trial at various dates until the pandemic hit, which caused massive delays. But even during that time period, in all these hearings, he's making very cogent legal arguments and proceeding with the case as it progresses ultimately to where it led. But he filed a number of things that clearly made sense and showed that he understood what was going on. And I would point out that both of his standby counsels who dealt with him practically from the arraignment on, both commented on the record that they had zero concerns about his competency in this case. And on top of that, you had two different prosecutors praising his legal filings and his intelligent and well-written pleadings, and the trial judge also commented on how well the defendant understood this process.
I struggled with trying to get the chronology right from the record. Can you maybe walk us through from the time of these offenses to the time of conviction, how that overlays with the federal proceedings? Because, of course, while we're not considering anything about the federal proceedings, I do find it interesting that there were these parallel proceedings that also would have involved some competency determination, and the record doesn't reveal any effort to build on those efforts in this case. And I think just understanding the chronology might help me understand why that happened.
Well, the murders were in late 2003 in December, near Christmas, and then I believe the federal case began around 2005. I printed up the docket sheet of that and went through that, and it progressed fairly quickly. I believe he was sentenced in 2006, maybe, or thereabouts.
When was he charged with these murders?
He wasn't charged in federal court with the murders. He was charged
when was he charged with the murders?
In 2016, he was indicted, and he wasn't arraigned until 2017. It was held under seal. I'm not sure really what was going on during that time frame, but as far as Your Honor's question, that the federal system, I didn't see anything in the docket sheet that indicated anything regarding competency. I don't think they incorporated that in the state proceedings whatsoever as to anything like that. Dr. Gamache, when he went to evaluate him for competency, I don't believe he looked at any of the federal things, although the parties did obtain transcripts of some of the trial proceedings at the federal level and utilized those. Certainly they utilized them in the penalty phase. And that was a basis for discovery that appellant was requesting those transcripts. And basically, this case coincided with the pandemic, so it had a very, very lengthy delay because when he was representing himself pro se, he couldn't get the voluminous discovery in his jail cell, and he was having to work with standby counsel and what have you. But they were able to obtain a massive amount of discovery, and the appellant was specifically requesting the federal materials. And once he got all of his discovery, that was his whole plan, he said, basically, was he wanted to get everything and review it, and that's when he decided to change his plea in this case. And I believe that, getting back to the competency thing, that the plea hearing, very thorough, and I think it's abundantly clear that the trial court didn't abuse its discretion in this case because he totally understood what was going on throughout this case.
Dr. Gamache, is that how you pronounce his name?
Yes.
Gamache. He considered, because obviously the defendant in this case would not meet with him, right, and so he can conduct a proper examination or evaluation. But he did watch him supposedly at trial and showed up or wherever he could, and he did make a determination that his whole business about the white supremacist thing, that was just Mr. Lorenzo just kind of playing the system, trying to stall. That was the doctor's belief that was probably what was going on here. And as you pointed out, Your Honor, that he did not speak with the appellant in any major capacity when he went to visit him at the jail, but he did speak to the correction officers that were in charge of him, and he spoke with standby counsel quite a bit as to what was going on in these proceedings and reviewed other material, and he found him competent. And of course the trial court did too. On the as far as competency, the colloquy that was conducted during the guilty plea, it seems that the judge conducted like Pareto type inquiries, not just at the plea conference, but throughout
every hearing practically. Yeah.
And that's a tiresome thing to do, but he just kept doing it, and actually kept asking me, "Sure you want to do this?"
Right.
That kind of thing. But interesting enough, the only thing that Mr. Lorenzo found conflict with was some minor details when the prosecutor provided a factual basis for the guilty plea.
Right.
And then once the prosecutor finished, Mr. Lorenzo's statement was dead on. That's what he used, the words he used, it was dead on, with final details. So as far as competency is concerned, I just don't see any situation there that shows that he was incompetent. If anything, he was an active participant in this entire defense.
He was very active, and as I pointed out, he made very relevant and cogent legal arguments and requests to the trial court throughout these proceedings. I don't think there's any question that he was competent throughout these. As to the second issue with the mitigation packet that was prepared by standby counsel, that was given to the state, I believe, about 2.5, 3 years before the change of plea here. And I point out that I question whether he preserved this because Mr. Lorenzo stated that he was objecting to that at a hearing 2 months before the penalty phase, and the trial judge said, well, we'll take that up when we get to it. And at the actual penalty phase, Mr. Lorenzo never objected again when the court requested that the state provide that report to him.
What is your response to counsel's argument that essentially he didn't have any option at that point and we should treat it almost like in an alternative? So if you're going to accept it, then I'm going to argue, but that the objection was still valid.
Well, one, he had time to think about it, and he was aware that Muhammad required the trial court to do this, and he pointed that out. I believe Justice Embargo said that at the Spencer hearing. He basically said, okay, I didn't really want you to do it at the time, but you're right, the Florida Supreme Court's going to back you up on this, that you had to do it. But the trial court specifically told him when he did object 2 months earlier, we'll take this up at the penalty phase. And I think it was incumbent upon him. They talked about it 3 different times at the penalty phase, and he never said, hey, I'm renewing that objection that I had to it. I think he changed his mind and was aware that the court had an obligation under Muhammad to require the state to turn over that evidence. And the court was following Muhammad. Now, Mr. Lorenzo said he wanted a death sentence. He wasn't going to present any mitigation at the penalty phase. So under this court's case law, the trial judge had to order the state to provide any mitigation in its possession, which standby counsel, when he prepared that 3 years earlier, said it was at the defendant's request that he was doing it. So that's not, that's evidence that the state has in its possession that under Muhammad the court's required to look at. And in sentencing Mr. Lorenzo to death, the trial judge really didn't utilize that packet very much. In fact, rejected a number of mitigators that were presented in that because there was no evidence to corroborate it. He did utilize the packet in finding some of the non-statutory mitigators, but he used it in conjunction with other items that were in the record to show that they had been established. But I don't believe that the court committed any error in this case by requiring the state to turn that packet over. If there are no further questions, the state would ask that this court affirm his judgment and sentence. Thank you.
Thank you.
The first thing I will rebut is the consideration of the federal trial, because that was not part of the record. The state wants you to consider that they had the opportunity to move to supplement with that position, and they did not. So I argue that any consideration of a federal proceeding are not relevant to this case because they're not a part of the record. Secondly, on issue 2, the state is acting as if Lorenzo did not want any mitigating evidence. That's not the case. He presented his own mitigation evidence. He had right to that being the only evidence considered. And he said 2 months before the penalty phase. And I quoted in my brief and the reply brief the exact objection where the court said, I'm going to consider that. And Lorenzo says, you're going to consider that even though I don't want you to. And the trial court said, yes, I am. So, the point of contemporary objection rule is to make sure the trial court knows what is being objected to and given the opportunity to address that objection. The trial court knew Lorenzo did not want that in the package. So even though Lorenzo did not object again, the trial court knew of his objection and had the opportunity to correct that. So therefore, the contemporary objection is satisfied. Unless you have any other questions, we will ask you to reverse the judgment and sentence either for a new jail free and penalty phase or at least a new penalty phase. Thank you.
Thank you very much. We're adjourned for today.
All right.